SJC-13395, Commonwealth v. Joseph W. James.
Okay, Attorney Levin.
Good morning, Your Honors. May it please the Court, Patrick Levin on behalf of Joseph James. This case is about the disposition of property seized pursuant to a valid search warrant after the criminal case is over and the Commonwealth no longer needs that property for purposes of an investigation or a prosecution. At common law, the state had no power to seize lawfully owned property just because it would help them investigate or prosecute a crime. Instead, every government seizure had to be founded on an assertion of a superior claim of right.
Can I ask you, just to kind of cut to the chase, Mr. Levin, the practical realities of what's going on, and I get your interpretation that the one paragraph isn't a standalone, you have to comply with the procedures in the ensuing
Yes, Your Honor.
paragraphs, which is really the heart of, I think, your statutory argument, or rule argument. So the police have a search warrant for drugs. They go into an apartment, they find drugs, they find a gun. After the case is over, we have lots of rules about what they can do with the gun and the drugs. Okay?
That's right.
They also find, during the search warrant execution, a box of plastic baggies, just a generic store brand, not even the good Ziplocs, right? A scale, and a bottle of inositol, which could be used as cut, but is a vitamin supplement. At the end of the case, can the police throw away those items? Do they have to give them back to the defendant so he can use them to manufacture more drugs? Or do they have to have a trial?
Okay, so the answer to that question, so this is a warranted search.
Yep.
So under Section 3, the police hold those items until after they're no longer needed for the trial.
Correct.
And then the judge has to make an order about what to do with them. So if the defendant, in practice, practically speaking, most of the time there's not going to be a fight about that kind of stuff.
Right, because he's not going to ask for the return of these things.
Right.
Okay, but we're making a rule in this case that's going to affect every case. And I don't know if the rule doesn't say the defendant has to initiate it with a request for return of property.
And that's right, and that's part of my argument, is that he shouldn't have to.
Right. And if you look at the rule strictly, he doesn't. So when you say, don't worry about it, it's not going to be an issue. I do worry about it because we're making a
that's
rule.
partially just to explain why it's 2023 and this is only coming up now.
Right.
Is that most of the time there's not a fight about this stuff.
Sure.
But I think the answer to the question is found in the federal cases that I've cited in my brief, which is that there is a presumption at the end of a criminal case once the government doesn't need the property anymore. The presumption is that the property should be returned to the person it was seized from unless it's subject to forfeiture or contraband or the government has some other interest in it.
So they can't throw it away without a trial?
So they can't, I mean, they don't necessarily need to have a trial if they talk to the defendant first and he doesn't assert any rights in it.
Yeah, but I'm trying to get you to the extreme case, of course.
Where he does.
Where he does, and we have to have every bag of Glad baggie or ShopRite baggies.
Right,
We have to have a trial.
And so part of that depends on how the case was resolved. And one thing that could have saved a lot of trouble in this case is, so there's a difference between a trial and a guilty plea, right? And so if there's a trial and those items are entered into evidence at trial, and then the jury convicts the defendant in part based on his having used those as instrumentalities of the crime, at that point there's been the relevant finding beyond a reasonable doubt. If there's no trial and the case is a guilty plea, one thing that it might behoove the Commonwealth to do if there's a concern about this kind of thing is to have the forfeiture of whatever the property is be part of the guilty plea. And so, for example, in this case, if they had if they had required Mr. James to agree to the forfeiture as part of his sentence and his guilty plea, that criminal forfeiture could have been constitutional.
If it's an instrument of the crime, it doesn't fall in the ensuing paragraphs? It's still, you still have to have.
If it's an instrumentality of the crime, then a forfeiture is permissible.
Right, but then you still
But the
have
process,
to have,
the question of the
notice in a trial.
the question of the process is like so the simple answer to your question is yes. If no one thinks about this or does anything about it, and then there is some assertion of a claim of right, it has to be resolved by means of a trial. And except that in the particular case that Your Honor raised as a hypothetical, that's a case under Chapter 94C, which has its own forfeiture provisions that are much less onerous in terms of what procedures are required. And so in that particular case, it would be a lot easier. They would only have to, make the motion in the criminal case and show that there was probable cause, and then the forfeiture could ensue. But in a case like this one, which doesn't have its own separate forfeiture provisions, and the general search warrant forfeiture provisions are the only ones that apply, then what is required is the notice and a subsequent jury trial, which is to be conducted, to the extent possible in accordance with the provisions that would apply in criminal cases, which includes a jury trial and proof beyond a reasonable doubt that the property is subject to forfeiture.
Because in this case, they weren't evidence at trial well, if it's a plea, right?
Right.
And it's an assault and battery, and the allegation is and they do a search warrant and they find a baseball bat, ABDW, and it's a plea. So there's no it's not the baseball bat isn't introduced as evidence.
Right, but the prosecutor presumably will
Does he get
give
his
a
bat
factual
back?
basis for the charge during the plea, and the defendant will admit, yes, I
Okay.
did assault and batter with that bat.
Does he get his bat back?
No, because that is an admission that the bat was an instrumentality of the crime.
Does
and
he get his
therefore-
bat back without a trial?
He doesn't get his bat back at all because so the guilty plea can establish that something is subject to forfeiture if the plea itself necessarily admits the relevant fact.
That's under the paragraph A, though, right? Because then the ensuing paragraphs give him a right to notice in trial, correct? I thought your whole premise was that provision that they used in the other case involving the Douglas murders. That isn't enough. You need to go through the procedural processes.
So the distinction here is that Mr. James has never admitted, and in fact there has never been any meaningful allegation that anything he wants back is connected to the crime that he pled guilty to.
Can I just ask you a factual question about that? Because I thought the Commonwealth suggested that some of the servers were linked to the underlying child porn. Is that?
So it's a little, so if you look at page 36 and 37 of the record appendix, you can sort of see what it is we're talking about. There's a picture of the computer with the 4 disks inside it. The question of the links between the various hard drives is sort of beside the point, I think.
Well, they're on the same tower, right?
They're in the same tower, right? And so the analogy that defense counsel was sort of trying to use during the hearing below is like photo albums. And so it would be sort of like a bookcase with 4 photo albums on it. At this point, they have returned the bookcase and one of the albums, and they're seeking to retain the other 3. There's also a separate external hard drive that I want to make clear is completely independent. It's not implicated by that claim at all. And that's what actually contains the bulk of Mr. James's portfolio.
So the external drive is not subject to the claim of this connectivity?
Right.
Okay, thank you. That helps, thanks.
But to the extent that there is a factual dispute about that, it needs to be hashed out through
At
some
the jury
kind of
trial.
evidentiary proceeding, which, yeah, if he doesn't waive his right to a jury trial, then that's where it would happen.
Is that the same for these So I understand they're pictures of other young women. We don't know their ages. He hasn't been prosecuted for other crimes, but I take it the police are worried maybe some of these people are underage. But, so that has to be sorted out at a trial, I take it? They can't just hang on to this because they're concerned that this may be other juveniles
That's right.
half naked.
And I want to be clear about what the allegation is in the affidavit from the state trooper. It's, I don't know how old these people are, and some of the images may be child pornography if any of them are under the age of 18. It's not even, he doesn't even assert that any of them would be child pornography if the people were under the age of 18. Now, the affidavit from Mr. James that's in the record shows that he does, in fact, know that none of these people were under the age of 18. And in fact, he says that he's pretty confident he would be able to prove that if he had access to the data that's on this computer. But
That data is on the external drive.
no.
No.
Only the photographs are on the external drive. All of his business records and everything else is on the computer itself, is my understanding. But that's not really clear in the record because we didn't have any evidentiary proceedings below. But at this point, the Commonwealth wouldn't even be able to get a warrant and institute a seizure and a temporary deprivation of the property based on the allegations that have been made about those other photos. What's in the affidavit is far short of probable cause that anything is illegal. And
But he's basically saying, I don't know.
exactly.
Yeah.
And I don't have enough to investigate. I can't make a judgment call about whether to investigate. I don't have enough information. I have these pictures. They may be porn, child porn, they may not be, but I don't know anything about these people, right? I take it that's
the essential nature of the allegation. And, at some point, the First Amendment overlay comes in, which is to say that to the extent that these photographs are not either obscenity or child pornography, they are constitutionally protected speech. And there's a whole separate, more demanding.
but in your view, that would
We
be.
just don't know, though, at this point with the record, correct?
Well,
Nobody's gone through these. How can you make a First Amendment determination when nobody really knows what's on
that's
there?
what I was about to say, is that even this court would not be able to make a determination as to probable cause without seeing the photographs.
Or whether it's constitutionally protected speech.
Right. A probable cause, yeah. And we know that from Commonwealth versus Rex, that like this court would need to look just to see whether there was probable cause of anything illegal in the photographs.
So that would be, again, that, in your view, that's why we have to have a trial on this stuff.
Well, in my view, it's actually probably too late to have a trial.
That
Like,
was my question, is when?
At-
When does
well,
this trial that you envision
so
going to happen?
what Chapter 276, Section 3 says is as soon as may be thereafter. At this point, we're well past that. I think, in fact, by the time Mr. James filed his first motion for return of property, we were probably past the point where it was too late for the Commonwealth to make a proper petition for forfeiture, which, we're talking like a 5-6 month delay after they didn't need this property anymore in order to investigate or prosecute the crime. And if you look at the federal cases, they suggest that length of deprivation of property without justification is a due process violation.
So not in this case, should there be a trial? Because you're just saying your client should just get it back.
That's right.
But going forward.
With one exception, which is that he never asked for the main hard drive of his computer back, because he does agree that his guilty plea establishes that it contains contraband. And so in my view, what is sort of the more...
Can I ask, is there a statute? I'm just looking at 276, Section 3 right now, that there isn't a time, there's no time provision in here, right?
What it says is as soon as may be thereafter.
As soon as, all property seized shall be restored to the owner, okay.
So in your view,
That as soon as may be thereafter, they were required either, the presumption would be to return any non-contraband property to the person that they seized it from, or to, if they didn't want to do that, to institute the forfeiture proceedings as required by law.
So just back to Justice Gaziano's practicality point. So all those evidence lockers filled with junk, they should have been returned so long as the case is over.
Well, so
all
there's,
those
the thing is, there are a lot of different statutes that potentially apply to different kinds of evidence in different kinds of cases. And none of those statutes apply to the evidence in this case, so I've only briefed the Chapter 276, Sections 3 through 8. But, you know, in drug cases, the 94C provisions apply, and a lot of the junk that's sitting around in evidence rooms relates to Chapter 94C cases. Obviously, these warrant provisions only apply to stuff that was seized pursuant to search warrants, so any kind of warrantless seizures, any search incident to arrest seizures have different rules, and those relate. And the other thing is,
I'm sure you and Justice Gaziano know this, I just don't. The clothing in these rape cases that are 20 years old, and doesn't have to be returned, I take it, or does it have to be returned?
so the victim's clothing in a rape case would be subject to.
I'm talking about the defendant's clothing.
Oh, the defendant's clothing. So I think that that kind of evidence probably is subject to Chapter 278A, Section 16, the forensic evidence preservation provisions, and which does make more specific provisions for preserving that kind of evidence until a date certain. And
I'm still a little bit confused about your statutory argument, because if you look at 276.3,
yes,
it basically says all property seized has to be restored to the owner and could be forfeited, and forfeited means either sold or destroyed. They want to destroy it.
right. So if
As the
forfeited,
public interest requires, go back to the baseball bat.
Yes.
So we have the baseball bat and an ABDW, case is over. You say, well, if the bat was used to hit somebody over the head, you don't get your baseball back. But then when you look at the ensuing sections, 4, 5, 6, 7, and 8, they all deal with notice, a trial, before an appeal, and the like. So when you say, well, if it's established in a plea that the baseball bat was used to hit someone over the head, you get to destroy it. But if you also incorporate 4 through 8, you don't get to destroy it. You have to have a trial.
well, okay, so I guess what I would say is what you should have to do if you're going to follow those statutes to the letter of the law
Which is what you're asking us to do.
is issue the required notice and see if anyone appears to contest the forfeiture. And if someone does appear, then at that point you have to have whatever proceedings they ask for.
Right, which is
And
I don't know if maybe the statute trumps practicality, but.
well, in going to the baseball bat hypothetical, right?
Right.
Someone else besides the defendant might appear and say, hey, that was my bat. And it maybe is not fair to them to destroy it without letting them
I'm
come
just
into
thinking
court.
of this procedural nightmare you're asking us to cause.
But
basically.
Well, I'm not asking
Doesn't Section
you-
3B answer Justice Gaziano's question about dangerous weapons? Because it says that, it specifies that those kind of dangerous weapons used unlawfully shall be forfeited to the Commonwealth.
Right, and so that's why I
Period,
say
full
that.
stop,
if-
without a trial.
That's why I say that if the criminal proceeding establishes that,
It was
that something
used.
was used unlawfully,
Yeah.
then that's probably going to do the
So
trick.
we're just talking about the extra stuff.
We're
Right.
talking about the baggies and the,
Right, well,
and the
yeah.
clo-
Are we
and the-
talking
and the
about the
clothing,
phones?
right?
we
Because, because, the baseball bat is like a diseased animal, right? So we don't have to worry about diseased animals, firearms, money, and weapons.
And I will say,
And
like,
what about telephones? How do telephones fit into this? Because I assume that those are going to be things taken, and they're of value to everybody, right?
so if a phone is seized pursuant to a warrant,
Right?
then the presumption would be that at the end of the case, the person whose phone it was should get the phone back. And this is a presumption, just to, one final word is, this is a presumption that in my view should be a lot stronger in Massachusetts than it is in the federal system, because we have an enumerated substantive right under Article 1 to possess and protect and enjoy property, which doesn't exist as enumerated in the federal Constitution.
Okay, thank you.
Thank you.
Okay, Attorney McGee.
Good morning, Chief Justice Budd, fellow Chief Justices. May it please the Court, Michael McGee for the Commonwealth. With the defendant
Ask
here,
you, why does the government get to keep something that they don't know is connected at all to any criminal activity?
as in the case here, the defendant was convicted of possessing child pornography, statutory rape, and enticement of a child. It's well within the discretion portion of 276, Section 3, for the defendant, for the judge, when provided an affidavit, had a hearing and evidence by form of affidavit also from the defendant, to weigh that and protect the vital public interests of protecting children from sexual exploitation.
I'm sorry, you think Section 3 exists in isolation and we have to ignore Sections 4 through 8?
Right.
It's from a procedural due process.
Life would be easy if there was no Section 4 through 8 for you, but there is.
In practicality, these circumstances happen at, like here, a motion for return of property from the defendant. As was the case in Gilday, the defendant here filed a motion for return of property, believing some of it was non-contraband and personal in nature, asked for a drive to be inventoried and some items to be returned. In fact, there were some items that the Commonwealth had agreed to return. As counsel alluded to, oftentimes the parties come to some kind of decision there. To answer your question, the Commonwealth was not mandated to pursue forfeiture of the items here. The proper procedure was done here. The defendant, in fact, was given a fair opportunity, had competent counsel, notice, and the opportunity to present evidence in the form of an affidavit. In fact, after...
You're saying the default position is you get to throw things away unless they ask for a return.
Oftentimes, and what I suggest be the proper procedure, is that after a case has run its course, and this is, again, alluding to 278A, Section 16, is that once a defendant has gone through probation, the appellate process...
But that 278A is the biological
and
evidence.
other evidence.
But I think you have to stick with 276, 3 through 8.
Correct.
Not go to the DNA statute.
From a policy standpoint, and this benefits both the defendant and the Commonwealth, as your honors are very well aware, there's appeals at all different points in time. And there's the retention of property is for a number of different reasons. This defendant here is charged.
But that's a little bit different. And the issue that I'm having here is these are things that he's asking for that are unconnected to the underlying prosecution and conviction or guilty plea, what have you. You would concede that, wouldn't you?
What I would suggest is that the devices in themselves there's a nexus between them and the crime. The defendant was convicted of possessing child pornography.
Sure, I know what he was convicted of, but the issue that I'm having is the affidavit that was presented on behalf of the Commonwealth seems to me screaming it's a CYA affidavit, where I don't know what it is. It could be potentially illegal, but I have no information that it is. So therefore, we don't turn it back over.
With all due respect, Your Honor, what I would suggest is that affidavit from a person that is well-educated and well-experienced in internet crimes against children.
Doesn't say that anything's illegal.
Says that even that trooper with all that experience and that civilian forensic examiner and no expert could determine the ages and identities of these individuals based upon just seeing them.
Sure.
That risk, that substantial risk of providing child pornography back to a convicted child, a person that's been convicted of that risk is substantial, and that the judge here was well within his discretion to not require the Commonwealth and its police that unwarranted and unsubstantiated burden of going through all of that and having to go through thousands of unidentified image files and really reaching the result that they can't determine whether it's someone under the age of 18. And that there is exactly why the judge was well within his discretion to deny the defendant's motion in part and not require that the Commonwealth go through and inventory that Kingston drive.
Let me ask you the further corollary to that, though. So if these items were seized pursuant to a warrant that we knew or at least was in the possession of the defendant, why would the tie go to the government?
The government didn't entice or possess child pornography, and most importantly, the government didn't commingle photographs, a cache of photographs of a 15-year-old girl within his own personal property.
But was it commingled? I thought they were all on the main drive.
There's a gaming tower, the Kingston Drive, which had evidence of the crime, admittedly to the defendant.
He's not asking for that back.
He's not asking for it. It was within the gaming drive, one of those, as we no longer have now, these computer towers. As explained by the trooper.
So because he had other drives in there, you're saying he's responsible for commingling, and this process that's delineated in the statute just doesn't apply?
What the judge was free to consider is that the trooper unambiguously explained that this was one interconnected.
I mean, I think the trooper's affidavit says, I don't know, I can't tell. It's a lot.
To just get back to this one computer aspect, that there was credible evidence there that these additional drives, the Seagate drives, the Barracuda and the other drive, were all added to increase space. That essentially you have a gaming tower
As
and
one does.
one screen, and that there's evidence within the Kingston drive that had the evidence of child pornography, of LNK files, link files that show that interconnectivity. There was credible evidence here that this was one computer and just simply additional drives to add more space for the user. So it was well within the judge's discretion here to allow the Commonwealth to retain those items and not to return it to defendants.
All of the items? Because I take it, there's a huge number of pictures here, some of which I take it are clearly adult pictures as opposed to potential kids, right? I'm trying to understand your commingling argument, how far it goes. If there's some interconnection between these computers, even though a lot of this is totally innocuous stuff, the Commonwealth can keep everything. Is that your argument?
There was competing motions here, but one of them, with respect to my commingling argument, was with respect to the Kingston drive. That the defendant asked that the Commonwealth take screenshots so that he could identify what was personal and then later on seek a copy of those. The commingling end here, and what I'm suggesting now, is that the Commonwealth, that the judge was well within his discretion to deny, is on that drive, the defendant had pictures of the 15-year-old girl, nude. He was convicted.
I understand that the drive that has the pictures of the 15-year-old girl who he's been prosecuted for, you can keep that, because, I mean, I guess you can keep it. But if the other stuff is only potentially, I don't, if it's severable, why doesn't he get to have it back? Even if it's got, I mean, okay, we got some people who are 50 years old in these pictures. We know they're not kids. They look like me. He doesn't get that back?
Going piece by piece here, there are 3 Seagate drives, as I was explaining, that were part of the gaming tower, which I would suggest are part of the one computer, that there's a potential that children could be exploited by providing them back to the person that was convicted of possessing child pornography. The other Western drive is 6.
Because, again, I'm not a computer person, but meaning because there may be something in this computer that we can't, we're going to have to dig too deep into this computer to know that there might not be some child porn on it. Is that the argument?
It's not a box of photos. These are sophisticated devices They talked about ghost files. They talked about different sectors of the computer systems. They didn't image any of them, but what they could determine from just going through the files, and even to your point about they could be on there, one of the Seagate devices had a similar file structure as even the Western, where it has the name of a woman and then proceeds to have a bunch of image files, not identifiable, that are all of a nude woman. Don't know her age, don't know who she is. Simply could be a capacity issue as to why that ended up on that Seagate. As to the Western drive, it's 6 terabytes. There was, I think, hundreds of thousands were referenced in Trooper Quirk's affidavit, and again, described as like image 1, image 161. To ask a police officer or the staff to spend months going through these individual photographs to determine something that's undeterminable, whether they are children.
So the computers are different from baseball bats and other things where you can separate the items. A computer is sort of indivisible.
Absolutely, and that's something that from a federal end, their statutory.
Are there cases that say that? Do the feds have cases that say that a computer is indivisible that way? 'Cause
Yes,
that would be
and
helpful. And those are in your brief?
They are, and what I cited to is 18 U.S.C. 2253, and Wernick was one of the cases, and the other name of the cases eludes me, but essentially the process that the case law suggests that the devices that are, if there's a nexus between the crime and the device, it's all have gone.
This is statutory interpretation.
Right.
And it's mandated.
Right. That's federal statutory
And it's
interpretation. We have to interpret 276 Section 3 to see whether or not 4 through 8 are part of it, or whether Section 3 is a standalone, essentially.
Correct. And what I would suggest to the court, and it was said, and I know it's an unpublished decision in Ricci, is that it's not required of the Commonwealth to seek a forfeiture proceeding to retain and eventually destroy.
As a matter of statutory construction, what's your best argument that it's a standalone?
It's a standalone?
Yeah.
As a matter of statutory construction, when an item is seized pursuant to a search warrant, it's under the direction of the court. And by its unambiguous and the letter of the law, it states that a judge has a discretion to dispose of, destroy, forfeit within the public interest.
Because when you read the statute, Section 3 says all this stuff may be forfeited, except, and it goes on to the things that Justice Wendland identified. But then it says, hey, here's the forfeiture procedures.
Correct.
So how isn't Section 3 tied to 4 through 8? Because it gives you the procedures for forfeiture.
What I would suggest to the court is that the Commonwealth would be well within its right to seek forfeiture of items and proceed with it.
That's why I'm just wondering whether we have to have trials for ski masks and or plastic baggies.
And what I'd suggest is that it's not mandated.
So we hand back the ski mask to the robber?
No. What I would suggest is that Superior Court Rule 61 and 276.3 taken together provide due process for a defendant like this one to have to seek property that they believe is theirs, that say if it was jewelry, commingled within jewelry, and to have a hearing, to have an evidentiary hearing even.
Nowhere in the statute does it say the stuff gets thrown out unless you file a motion for return. The burden's on the government to destroy and justify destruction, right?
There's nowhere in the statute that says whose burden it is to prove. But what I would
there's the constitutional provision that your opposing counsel mentioned, that
Right,
property
I think it would
belongs
be a little
to.
backwards if we said everything gets thrown out unless you prove.
This is a civil equitable remedy, though. At the end of the day, this is not deprivation of liberty.
Well, Beldotti was easy.
Property,
Well,
though.
Beldotti was easy. The judge basically said, "Come on, you're kidding me. We're going to get rid of that." But that's not this case.
Well, Your Honor, the Commonwealth and its citizens have a interest in protecting children and their safety. And
Right,
this
but
is
you don't know. All you have is an officer saying, I can't tell if these are children.
thousands and thousands of pictures.
Right, and
we
I
can
don't
tell
know
that
if
this-
any one of them is a child. I can't possibly tell, because it would take me too long. But I'm going to keep it and destroy it.
and-
Even the wedding pictures of somebody else who owns a copyright to those.
And the judge was free to credit that the officer did refer to them as young, and that we have a defendant here that went to state prison for 7 years for enticing, for explaining to her how she could sneak out of her house to meet with him, and took photographs of her and kept those photographs. He was free, being the judge that took that plea, and also that did the first motion in 2018 and heard all these arguments, to reject that based upon that affidavit and allow the Commonwealth to retain them. He denied the Commonwealth's motion to destroy it without prejudice, but he refused to return this to the person who admittedly possessed child pornography.
None
and
of
that
which
was well
is
within his
this,
discretion.
right? None of which was the other things that he's asking for.
Excuse me?
He admitted to possessing child pornography, but none of it was the things on the 4 drives he's asking for.
No, and what I believe, and I would suggest was well within the judge's discretion, is not requiring the Commonwealth, who did not commingle all this and did not possess all
Counsel,
the...
I know you're over time, but I still go back to Justice Casiano's point about do you just get to carve this out or not? Because you still say commingling. So I understand there's one tower, and just for the uninitiated, that you could slide in 4 different drives. And just because, and you could pull out 4 different drives. You can take out 2, you can take out 3, you can take out 4. So when you say commingling, just because they're all housed in the same tower, doesn't mean that they're not easily segregated. So you could pull that out, right? So the ones that we're talking about that we don't know what the images are and that they could potentially be contraband or unlawful, why isn't it that the other parts of the statute then are triggered? Isn't it even more important that they're triggered, the procedural aspects? Because we don't know if they're at all unlawful or that they may be potentially contraband. So wouldn't that make sense that we have these other procedures that we go through this trial, particularly in this case?
In this case, and in particular to this case, the defendant had that opportunity and had a zealous counsel arguing for all of that and making all of those arguments in a hearing. In 2018, had notice, provided an affidavit, waited till 2022 to then say, oh, there might be, through the form of an affidavit, these other persons, never providing names or anybody that's actually seeking any of these wedding photographs or engagement photographs, none of that. And the judge was free and well within his discretion to discredit the defendant's affidavit.
Thank you.
Okay.
Unless if there's anything further, I'd rest on my brief and ask the court to affirm.